On June 18th, the Titan submarine suffered a catastrophic implosion in the North Atlantic, instantly killing all 5 passengers on board, including the owner and CEO of OceanGate, Stockton Rush. There will be legal action around this, and this will inevitably go to court. And when it does, I believe that it will all center around the insane language in the release of liability agreement. Imagine for a second that you're one of the wealthy adventurers that decided that you wanted to go to the bottom of the ocean to see the Titanic. And across the desk from you is sitting this waiver. I have been informed about the nature of the operation and the risks it presents, including that a portion of the operation will be conducted inside an experimental submersible vessel. The experimental submersible vessel has not been approved or certified by any regulatory body and may be constructed of materials that have not been widely used in human-occupied submersibles. Even if you've been desensitized to all the liability waivers you have to sign, reading this should scare the crap out of you. We're talking about taking what is practically a glorified soda can and taking it to the depths of the ocean with crushing pressures. And they're telling you that it's never been approved, that it's never been certified, and that the materials, those same materials that are supposed to keep you safe, are not used for human occupants. Right off the bat, this language is insane. I will be exposed to risks associated with high pressure gases, pure oxygen servicing, high voltage electrical systems, and other dangers that could lead to property damage, injury, disability, and death. In a second version of the document obtained by Insider, it says, I am aware of the risks associated with participating in this activity, which may include, but are not limited to, physical or psychological injury, pain, suffering, illness, disfigurement, temporary or permanent disability, including paralysis, economic or emotional loss, and death. And I understand that these injuries or outcomes may arise from my own or others' negligence. So if you notice, this text is in all caps and bolded, which is interesting. Some of you may have seen this in documents that you've read in the past and wondered whether it has any legal significance. And the answer is, it does, or at least it can. A lot of times when courts look at language in releases, what they're looking for is conspicuity, which means how obvious is it? Are they really trying to shout at you literally from the page? And that can change the legal outcome of whether or not these releases apply. This all seems pretty conspicuous. It seems pretty obvious, pretty straightforward that whoever chose to get on this submersible knew what they were getting into and signed away their rights to be able to bring any sort of lawsuit. Doesn't this just wash the hands of OceanGate for all responsibility for this disaster? The answer is maybe not, because oftentimes in these cases, these releases don't apply to what we call gross negligence. That's when you didn't just do something kind of bad, but you did something really bad. If you know your roller coaster's broken and you keep sending riders on and just handing them liability waivers, you're not gonna get off scot-free. Liability waivers do not protect companies from their gross negligence that leads to the injury or death of their customers, which seems like OceanGate could be guilty of here. However, there is a separate legal doctrine that applies to ocean-going vessels that could protect OceanGate from responsibility in this case. In fact, it's called the Limitation of Liability Act of 1851, which says in short that any ocean-going vessel, a vessel that's on navigable waterways, which means any rivers or bays that lead into the ocean, that is involved in an incident that causes injury or death to a crew member or a customer on board, can limit its legal responsibility to the value of the vessel itself. For example, let's say you're sailing on a boat in 1910 and the boat goes up in flames and everybody on the boat is either injured or tragically passes away. But the only thing that is recovered is the anchor, and the anchor is worth about $150. The owner of that vessel can limit their entire responsibility for that tragedy to $150. So in this case, what would be the value of the imploded Titan submarine? Nothing, or essentially nothing, which means that the company, OceanGate, is going to try and limit their legal responsibility in this case to essentially nothing, unless it can be proven that the vessel is unseaworthy, which means that it's unsafe for the voyage that it's intended, and that the owners of the vessel had knowledge of the unseaworthy condition, meaning that OceanGate, the owners of this submarine had knowledge that this thing was unsafe. It's been reported that a former passenger named Carl Stanley, in fact, wrote an email to Stockton Rush telling him that he observed crackling sounds as the Titan went deeper and deeper on one of the voyages. Another piece of evidence that could prove both unseaworthiness and knowledge of unseaworthiness is the release itself. The release on page 2 says that the risks can include, without limitation, drowning in malfunction or failure of the submersible leading to death or serious injury. Now that is very specific language. That's exactly what happened on this incident. The argument can be made that OceanGate knew that this was a serious risk, that the failure of this submersible on the voyage was a serious danger, and that could be used to help prove the case of unseaworthiness. But the owner and CEO of this company, Stockton Rush, was on this sub. He tragically passed away as well. And so can we really say that he, with all the knowledge that this was an unsafe and dangerous voyage, chose to put himself on the vessel too? These are all facts that a court is gonna have to wrestle with. Ultimately, a lot of these issues are gonna boil down to the insane language of this release. And the release will be used as a sword and a shield, meaning the people bringing the lawsuit are gonna try and use this as a sword to prove their case, while OceanGate and those defending the lawsuit are gonna use it as a shield to protect themselves from any liability. But this isn't the only legal issue that the courts are gonna have to wrestle with. We still don't know whether there is insurance involved in the case. We've got a company that's based in Washington and another company based in Bahamas, and we don't know whose law is gonna apply. We don't know whether the corporation is gonna stand and continue to go on, or whether it's defunct and going out of business with a CEO that's passed away. There are a lot of unknowns, both legally and factually, that still have to play out in the future. Now, this is a tragic situation in which families have lost loved ones, and a lawsuit might be the last thing on their minds. But a lawsuit is inevitable. And from a legal perspective, it's incredibly interesting and fascinating to see how this might unfold in the future. And we'll certainly be following along, and I'm looking forward to bringing you guys an update when we have one. In any case, thanks for spending your lunch break with me today, and I'll see you next time.